Section 47 and 48 of the Landlord and Tenant Act, guys. This is an act that's been out since 1985, 1987. Just wanted to revisit this for you. Okay, so landlords, there's two acts here. Section 47 of the Landlord and Tenant Act, Section 47 quite simply states that the landlord's name and address should be provided on all demands for rent payments. So a demand for a rent payment is a tenancy agreement. A demand for a rent payment is an invoice. A demand for a rent payment is an arrears letter. If on any of those three things you do not have the landlord's name and address, then legally that rent is not deemed due until it is provided. Why do I say this to you? So firstly, if you do your own tenancy agreements, please make sure that you are providing your name and your address. If an agent is doing your tenancy agreements, please make sure that they are not using their address, because it shouldn't be the agent's address. For the purposes of Section 47, it should be the landlord's address. If you're an overseas landlord, you do not live in England or Wales, you will also have to provide an alternative address for service of notices, but that will fall under Section 47. So Section 48. So Section 48 of the Landlord and Tenant Act states that an address should be provided to the tenant in England or Wales for service of notice. This address can be the agent's. So under Section 47, you have to provide the landlord's address. Under Section 48, you have to provide a address, and that could be the agent's address. Again, if it's not provided, then any rent due would not be deemed due until it is provided. If your address is on your tenancy agreement, as it should be, and you move house during your tenancy, you must notify your tenants under Section 47 and 48 that the address has been changed. You must notify them. If you don't notify them and you serve notice later in that tenancy, the notice will be invalid if you haven't. I hope that makes sense. Right, there's also a law that you guys need to know about that us as agents have to adhere to, and so do you as a landlord. So let's say an agent doesn't put your address on the tenancy agreement and they put their own address on there because you might not want your address on there, which unfortunately I would tell you that really it should be on there to comply with the law. The tenants can request this information. They can send a written request to either you as the landlord or us as the agent and request an address. An address means the landlord's place of residence or place of business, and in the case of a company landlord, its registered office. Now, once that request has been received, the agent or the landlord has 21 days to provide a response. Now, please bear in mind, I've said here that if you don't respond and you don't comply, rent could be deemed not due. We don't want that. We don't want to be in a situation where rent is not due. Another thing to note, guys, about ownership and addresses. Some of you may buy a property that has got a tenant in there. Some of you may sell a property. Some of you may take over a rent-to-rent tenancy, whereby the ownership, the assignment has changed. If ownership changes during a tenancy, then under Section 3 of the Landlord and Tenant Act, you must notify the tenants. So now you must comply with Section 3, Section 47 and Section 48. And Section 3 of the Housing Act quite simply states ownership has changed during the tenancy agreement. I am writing to notify you of that change, of that assignment. I am the new owner. And you then don't need to do a new tenancy agreement, because the tenancy agreement that was with Mr. Smith as the landlord here is legal as Miss Bennett, the owner here, because we've served Section 3 of the Landlord Tenant Act on the tenant. Now, section 3, when ownership changes, this should be given to the tenant no later than the next rental due date or 2 months after the assignment. No later than the next rental due date or 2 months after the assignment, whichever is the soonest. And as I've said here, you must ensure section 47 and 48 handled too, otherwise you may be in a position where rent does not become due.